Ever wondered what happens when a legal case gets, well, really complicated? Like a high-stakes game involving challenges to judges, the court system itself, and even fundamental rights like staying silent. Today, we're doing a deep dive into exactly the kind of fascinating real-world legal battle from the Seychelles Court of Appeal. Our mission, really, is to pull out the key takeaways from this complex judgment. We want to help you understand things like court hierarchy, judicial impartiality, constitutional rights, but in a way that's actually engaging, you know? Think of it as your shortcut to getting informed about appellate law and the crucial rules of the game.
Absolutely. We're focusing on Sidney Cliff Parrick versus the Attorney General. It's a case that really shines a light on justice, due process, and something often overlooked, the need for litigation to actually end somewhere. Finality. We'll explore why picking the right legal path and understanding the finer points of constitutional rights are just so critical.
Okay, so let's set the scene a bit. Sidney Cliff Parrick. He was convicted, right, for counseling or procuring murder by the Supreme Court with a jury. He then appealed that to the Court of Appeal, which said no, dismissed his appeal. But that's where it gets really interesting because he didn't stop there. He tried a different route.
That's exactly right. So after the Court of Appeal upheld the conviction, Mr. Parrick went somewhere else entirely, a constitutional court. His main claim there was that the Court of Appeal justices, when they dismissed his first criminal appeal, had violated his constitutional right, specifically Article 19(2).
That's the right to silence one.
Correct. The right not to have bad stuff inferred just because you stayed silent. But the Constitutional Court didn't even really get into the merits. They dismissed his petition. They agreed with the Attorney General, who'd raised an objection, basically saying, wrong court, wrong procedure, jurisdiction issues.
Ah, okay. So this appeal, the one we're diving into now, is Mr. Parrick appealing that decision by the Constitutional Court. And he's bringing up some pretty big arguments, asking judges to step down, questioning if he was in the right court, even if he filed on time. It's a real look under the hood of the legal system. All right, first big issue then. This request to have two judges, including the president of the Court of Appeal, recuse themselves. That's pretty dramatic stuff.
It is, yeah. A very serious application. Mr. Parrick argued that these two justices, plus another one who actually did recuse herself, had already heard his original criminal appeal. He claimed they'd violated his right to silence back then by drawing that adverse inference. So his point was, how could they be impartial now? He used the legal test. Would a fair-minded and informed observer reasonably think there's a risk of bias if these same judges heard this appeal about the Constitutional Court's decision, which touched on that very same alleged violation?
And there was something about an email, too, from the deputy registrar?
Yes, he pointed to that as well. He felt this email sort of jumped the gun, suggesting his appeal was late and confirming the Court of Appeal was the right place, implying the justices had already made up their minds.
Okay, sounds like he had some grounds, but the Court of Appeal didn't agree.
No, they firmly rejected the recusal application. They went back to that fair-minded and informed observer test. They stressed it's objective. It's not about what the person involved feels or suspects, but what a reasonable outsider would think. And fundamentally, judges have a duty to hear cases unless there's a really clear lawful reason not to.
So why didn't they see a clear reason here? What was their justification?
They clarified that their role in the first appeal, the criminal one, dealt with different legal and factual questions about his actual conviction. This current appeal wasn't about reopening that conviction or even deciding if his Article 19(2) right was violated back then. It was purely about whether the Constitutional Court made a legal error in dismissing his petition. Importantly, the Constitutional Court hadn't made any findings on the bias claims themselves, so this court wasn't reviewing those facts. And the email. They said it was just administrator communication, standard stuff, not some kind of judicial prejudgment. They pointed to their oath to be impartial. No objective bias found.
Okay, that makes sense. Let's move to the next big hurdle he faced. Was he even in the right court? And was he on time? This gets into the structure of the courts, doesn't it?
Absolutely. This is where understanding the Seychelles court hierarchy is key. The Court of Appeal is explicitly the top court, the apex court, highest in the land. The Constitutional Court, however, isn't separate like that. It's actually a division of the Supreme Court. So it sits lower in the hierarchy than the Court of Appeal.
Right, which means, well, the lower court can't just overrule the higher court, can it? Especially not on something fundamental like interpreting the Constitution.
Exactly. That's the principle of stare decisis.
Yeah.
Lower courts are bound by higher court decisions. Yeah. It's fundamental. The Court of Appeal is very clear. Letting someone challenge their decisions in the lower constitutional court That would just create a never-ending saga. There'd be no finality.
No end to the legal battles.
Precisely. And finality is a core goal of any justice system. They even cited a previous case, Frankie Simeon VR, which basically said trying to reopen Court of Appeal issues via a constitutional petition is an abuse of process.
Abusive process. That sounds quite serious. What does that actually mean for, someone listening? Is it like deliberately messing with the system?
It can be, yes. Or it can simply mean using the courts in a way they weren't designed for. Like trying to get around established rules or relitigate something that's already been settled definitively. It wastes time, resources, and undermines the authority of previous judgments. So the courts have to step in and say, no, you can't do that.
Got it. And what about the timing argument? He tried to say his issue was substantive, not procedural, to fit it into the constitutional court's remit and maybe get around the deadline.
Well, the court didn't really buy that distinction in this context. They saw his whole challenge as basically a collateral attack, a sort of sideswipe at the merits of the Court of Appeal's original decision. And that kind of challenge, especially on a substantive issue, belongs in a higher court appeal, not a new constitutional case in a lower court. Plus, crucially, they found his appeals just way too late. Time barred. The rules are clear. You have 30 days to appeal a Court of Appeal decision. Mr. Perek filed this appeal nearly, 1 year and 9 months after the original judgment he was effectively trying to challenge.
Wow, okay. 1 year and 9 months versus 30 days. That's quite a difference.
A very significant delay, yes. The court called it a veiled attempt to overcome the time limit. The thinking might have been, go to the Constitutional Court first, which had a longer initial filing window, lose there, and then appeal to the Court of Appeal, trying to reset the clock. But the court stressed, rules are rules. They have to be obeyed. You can't just ignore deadlines like that without a very good excuse, which wasn't found here. They also mentioned that clients are generally stuck with their lawyers' actions or mistakes.
Right. So the case was dismissed on those grounds, recusal denied, wrong court, too late. But interestingly, the court still talked about his original argument, the right to silence thing. Why bother if the case was already over?
That's a good question. It seems they wanted to really hammer home the point that his whole approach was problematic. By showing that his core constitutional argument was, in their view, weak or frivolous, it reinforced their conclusion that this was an abusive process. They looked at Article 19.2, no adverse inference from silence, but they pointed out it's a qualified right, not an absolute one.
Qualified. What does that mean practically? If you have a right, isn't it just a right?
Not always so black and white. Qualified means there are specific situations or conditions where the right might apply differently or where other factors come into play. Here, the court highlighted two key things. Mr. Perek had given 2 police statements voluntarily earlier on, and crucially, at his trial, he didn't object when the prosecution introduced those statements as evidence against him.
So by letting his own earlier statements in without objection, he kind of opened the door. He couldn't fully rely on silence at trial anymore.
That's precisely how the court saw it. They said by not objecting, he jumped into the prosecution arena. In that kind of situation, where there's strong, compelling evidence against you that points directly at you, and maybe only you could explain it, well, your failure to offer any explanation can logically be considered by the jury or judge. It's not forcing a confession. It's about responding to a strong case already presented. They mention, for instance, his initial lies to the police or unexplained phone calls around the time of the killing things only he could really shed light on.
So that's where the human reason and common sense idea comes in. The idea that sometimes silence in the face of strong evidence just doesn't make common sense.
Exactly. The court drew on common law principles from other countries supporting this. The right to silence is vital, but it has to be balanced against logic and common sense when a solid case demanding an answer has been put forward. And importantly, they noted Mr. Perek himself had admitted the right to silence issue was argued during his original criminal appeal. It wasn't a new point. It had already been considered and decided by the Court of Appeal back then.
Okay, one last point. He had a fallback argument, right? If the Constitutional Court was the wrong place, couldn't they have just transferred the case up to the Court of Appeal? That sounds sort of reasonable.
It might sound like a practical solution, but legally, the court said, absolutely not. They dismissed that ground completely. There's simply no legal mechanism, no rule, allowing the Constitutional Court, the lower court division, to transfer a case up to the Court of Appeal, the higher, apex court. The specific constitutional article he tried to rely on for transfer is Article 46, deals with sending cases to other lower courts for specific types of redress, like damages for unlawful arrest, not for punting a major constitutional challenge upstairs to the highest court. It just doesn't work that way structurally.
Wow, what a journey through the legal maze. This deep dive really underscores how vital all those procedural rules, the court structure, and how rights are interpreted actually are. It's not just theory.
Indeed, it powerfully illustrates that principle of finality legal battles have to end. And it gives a fascinating insight into how even a fundamental right like silence isn't absolute. It interacts with the facts, with procedure, with common sense.
So what's the takeaway for you listening? I think this case really shows that in law, how you pursue your case following the rules, choosing the right court, meeting deadlines is often just as important, maybe even more important than the substance of your argument. Getting the procedure wrong can mean you don't even get a chance to argue the merits. It's a reminder that procedure isn't just red tape. It's fundamental to how the system ensures fairness and order.
And maybe it leaves you thinking about this. We hear a lot about rights, but how often do we consider the intricate rules of the game, the procedural framework that determines how those rights are actually asserted and protected? This case suggests that understanding that framework is crucial for understanding justice itself.